Good afternoon. My name is April Renner. I am an attorney at Bugbee & Conkle. I've only been here since January. Before this, I was practicing medical malpractice defense. Although I've only been practicing for a few years, I've been in the legal field since 2001. I started as a secretary and then moved up to a paralegal helping in labor and employment and workers' comp. And then I left to go to law school, specifically to become a workers' comp attorney. It just took a couple years before this opportunity arose. I'm really excited that I can be part of this firm. And incidentally, the first hearing that I handled was on idiopathic injuries, and that's the topic today. Okay, so not all injuries that occur at the workplace are compensable. To be compensable, an injury must occur in the course of employment and arise out of employment. Arising out of employment means that there's a causal relationship between the injury and the employment. An idiopathic injury occurs in the course of employment, but it does not arise out of employment. Instead, it arises out of something particular to the employee, and that something is usually the employee's weakness, physical weakness, or some sort of condition, medical condition. Idiopathic injuries are generally not compensable, but there is an exception. An idiopathic injury can be compensable if a condition of employment increases the risk of injury or causes the injury to be worse or more dangerous, and this satisfies the causal connection that's required. Sometimes we have injuries and we have no idea what caused them. In those claims, the employee must eliminate idiopathic causes. If the employee fails to do so, the injury is not compensable unless there's something about the employment environment that was an added risk or harm. If the employee does eliminate idiopathic causes, there's an inference that her injury was from a risk she was exposed to in her employment environment. But this is not all she needs to show. So she also needs to show that there is a causal connection. And a lack of evidence that a force or a condition that's independent of her employment caused her injury is usually sufficient. Okay, so for the remainder of the time, rather than lecturing, which I kind of just did, we're going to go through some real claims. And I'm going to give you the background of the claim. I'm going to reveal whether the claim was compensable or not compensable. And then we're going to talk about why. Some of these I will actually ask for your input of what you think, whether you think the claim was compensable or not. So some of these claims are reported court cases. That means that they had been through the Industrial Commission and also through courts. And then other claims are claims that are firm handled in front of the Industrial Commission. And as such, you may recognize some of these claims. As you're about to see, the compensability determination of these claims is very fact-specific. It might also appear that some of the decisions are subjective or inconsistent. They might not make any sense, and I've definitely been there where they seem like they don't make any sense and they don't seem fair at all. The reason is we're dealing with hearing officers who are just like us, unique. They see things through different lenses, and so you might get one decision from one hearing officer and a similar claim in front of another hearing officer, and the decision is completely different. For these examples, I've grouped the claims by the mechanism of injury. And first, we're going to start with falls. There are various factors that determine whether an injury from a fall is compensable. One factor is what the employee hits when he falls. So here is the first scenario. An employee for a newspaper had a seizure and fell, striking his head on the concrete floor. His injury was not compensable. He fell due to an idiopathic condition, which was the seizure disorder. The concrete floor was not an added risk of his employment. The court noted that concrete is a common surface material in many buildings outside the work environment. So in other words, his injury could have happened anywhere. Okay, so for the next case, an employee suffered a heart attack and fell, hitting his head on the cement floor of the employee restroom. His injury was not compensable. His injury was idiopathic because it was caused by a heart attack, And just like the concrete floor, the cement floor was not an added risk or hazard incident to his employment because the cement floor is a common surface just like concrete floor. Last one. A store cashier was walking into the restroom because she was not feeling well. She fainted and hit her head on the floor. Her injury was not compensable. It was caused by her pre-existing illness, her not feeling well, and there was nothing incident to the employment that increased her risk of injury, and again, she fell onto a common surface. So you can see the trend that when an employee falls onto a common surface not specific to their employment environment, the claim is going to be not compensable. The result is different, however, when the injury involves a piece of equipment or furniture that is part of the employment environment, and that is what they hit. So we're going to go through a couple examples of that. First one, an employee had a seizure and fell, hitting his head on the corner of a welding machine. The impact caused a concussion from which he died the next day. That's compensable. Although the injury itself was idiopathic, the welding machine increased the dangerous effects of his fall. The machinery was the added risk incident to his employment. For the next case, a gas station clerk was waiting on a customer, and he fell and hit his head on a cabinet. In this case, there was some arguments as to whether or not he fainted or whether he tripped over a stool, but regardless of that, his claim was compensable because the cabinet that he struck was part of the employment environment. Now, for this other case, I want to get your input on it. A factory worker was sitting at a picnic table in the cafeteria waiting for his shift to start. The company permitted employees to clock in before their start time and wait in the cafeteria until their shift started. As his shift started, the employee arose from the picnic table to proceed toward his work area. He fainted and struck his head, well, his face, on one of the picnic tables. Do you think that this injury was compensable or not? Type your answers into the chat box. Compensable is right. So the court found that the claim was compensable, and that is because although he was not in his workstation, so he wasn't working at the time, the picnic tables in the cafeteria were considered beneficial to the company because they helped facilitate shift changes, and so therefore they were considered part of the employment environment. And then I have another one for your input. A teacher's assistant was in the restroom tying her shoes. She stood up too fast after tying her shoes and became dizzy. She then fell, striking her head on the sink. Do you think that that claim was compensable or not compensable? Nobody. All right, well, this was not compensable, and the reason is, well, it was idiopathic because she became dizzy. And the court found no causal connection because although the restroom sink was a fixture in the environment, she performed her work duties in the classroom, so it wasn't technically part of her employment environment. Another factor with falls is whether something in the employment environment precipitated the fall. And I personally have handled two of these claims. So the first one I handled was a worker at a fast food restaurant was walking through the kitchen area when she passed out and fell. And this was a pretty easy one. This was not compensable. She actually had a history of a condition called POTS, which is characterized by fainting. And we had a video that we showed her walking through the kitchen area. There was nothing that she slipped on. There was nothing that she tripped on. So it was a pretty easy claim. The hearing officer disallowed the claim, finding that the fall was idiopathic and that nothing in her employment environment contributed to her fall. And then the next case I handled, an office worker was dropping off papers when she slipped and fell, injuring her back. She testified at the hearing that the floor was not wet. She also noted that she was wearing high heels, but she said she did not think that caused her fall because she wears high heels all the time and has never fallen. She just didn't know why she fell. This claim was not compensable. So for this claim, we had prior records that showed that she had an extensive history of back pain and that she also had falls, even though she said she did not. And we used this evidence to show potential idiopathic causes of her fall and of her back complaints that she was saying was related to this injury. The hearing officer disallowed the claim, finding that she failed to eliminate these idiopathic causes and that she failed to provide an employment-related explanation as to why she fell. Another claim that our firm handled was where an employee was actually not even sure what happened. She was not sure how she fell. And in that claim, it was a teacher's assistant. She put her personal belongings on the floor, and she turned to walk into a room for a staff meeting when she fell and landed on her knee. She said in her statement, as well as the company incident report, that she may have tripped over her tote bag, she may have tripped over the leg of her chair, but she really did not know. It would only be speculation. This claim, surprisingly, was compensable, which to me makes no sense. So we argued that it was unexplained fault because she said she did not know how this happened, and therefore she had to eliminate idiopathic causes. To do that, she testified she never fallen before, she never had any problems with her knee, and we argued even if that was enough to eliminate idiopathic causes, she could not prove a causal connection between her injury and employment because she said she did not know how she fell. Regardless, the hearing officer disagreed and allowed the claim. He found that the injury arose out of her employment because although the cause of her fall was not conclusively established, she eliminated idiopathic causes through her testimony. And for him, that was enough. And we're sitting here wondering, well, what about the causal connection? She hasn't proved that yet. And so needless to say, this particular claim is into court right now, where it is pending. And yet another claim we handled, a factory worker turned away from the line she was working at and fell, fracturing her leg. She presented statements from coworkers that the matting under her feet was filled with tears and holes. The company representative, however, testified that there were no tears and there were no holes in the matting where she fell. The employee testified she had no prior unexplained falls or any problems with her legs giving out. What do you think about this one? Do you think that this was compensable or not compensable? Okay, yep, this one was compensable. And the hearing officer found that her testimony of good health was sufficient to eliminate the idiopathic causes for her fall, and therefore it was appropriate to make the inference that her fall was caused by a risk, even though it was unidentified. The hearing officer noted that at the very least, even though there was conflicting testimony, the matting was worn, and so that could have contributed to her fall. Okay, one less fall. A factory worker left her workstation, which was drafty and very cold. She went to the restroom where it was warm and decided that she would sit on a trash can. She went to sit down and she fell, presumably because the trash can was unstable. What do you think on that one? Do you think that that was a compensable claim or not compensable claim? It was compensable. So her testimony that she was in good health was sufficient to eliminate idiopathic causes. And even though she was in the restroom, so she was not in her work area, the restroom was under the employer's control, is what the court decided, and therefore, and restroom breaks were incidental to her employment, and therefore, the trash can was considered part of her employment environment. Okay, so moving on to a new mechanism of injury. Injuries from climbing stairs or walking up steps. So for the first one, an employee walked upstairs to retrieve mail and paperwork as part of his job. He was in a hurry because he needed to get ready for the company Christmas party. As he was walking briskly down the stairs, his knee buckled and twisted. This one was not compensable. So the court noted that he had pre-existing knee problems which caused the buckling, and there were no evidence that the stairs were unsafe. Plus, he created the hazard by hurrying when he was walking down the steps, and it was not required that he walk fastly so he could get to the Christmas party on time. We handled a similar claim in the Industrial Commission. A warehouse worker was walking briskly down steps when he felt a pop inside his knee. His claim was also not compensable. The hearing officer found the employee's pre-existing knee problems were an idiopathic cause of his injury. So in order to prevail, he had to prove that a hazard of employment created an increased risk of injury. And like the one before it, the hearing officer found that there were no evidence that the steps were unsafe and therefore disallowed the claim. Next one, an electrician was walking up steps to get his blood pressure checked by the plant physician. He put his left foot on a stair and it slipped off. He heard a popping and cracking sound. An MRI showed a meniscus tear. The employee had a prior knee injury and clear degenerative changes in his knee, but he testified that he had not sought treatment for years and his knee did not cause his fall. This claim was not compensable. So the hearing officer still disallowed the claim, finding that there was no hazard unique to his employment to establish a causal connection. A factory worker was switching from one machine to another, which involved walking down steps. As he walked down the steps, he felt a tear and pull in his knee. His claim was not compensable. The hearing officer noted that there was nothing on the steps to cause the employee to slip, and the employee was not carrying anything while he was walking down the steps. The hearing officer found that the injury did not arise out of employment, saying that there was no causal connection between employment and the everyday activity of walking down steps. And so that leads to the next type of idiopathic injuries, injuries from ordinary everyday movements. The first type is injuries from just turning your body around. A store clerk turned his body to hand his manager a receipt and felt pain in his lower back and down his leg. He was diagnosed with a lumbar sprain. His claim was not compensable. The court noted that the employee was not lifting, pushing, or pulling anything. Instead, he was just turning around, which is a normal movement that could have happened anywhere. Therefore, it was not a hazard of working in his employment environment. Next one, an employee was walking briskly when all of a sudden he stopped to turn around quickly and his knee popped. This one was also not compensable. The hearing officer disallowed the claim, calling the incident merely coincidental to his employment and not caused by anything in his employment environment. And of course, those are very easy to figure out. The next ordinary movement, bending. I'm going to have you help me with the first one. This involves a sales clerk at a bakery. He bent down to retrieve an empty tray to place baked goods on when he felt pain in his back. He had not lifted anything yet. Do you think that this claim was compensable or not compensable? Right, claim was not compensable. The court found that bending down is a common activity and his risk of injuring himself at work while bending down was no greater than for the general public. We handled a similar claim to that, where an employee alleged a low back injury while he was lifting parts. But we presented a video of the incident which showed that he had bended over, but he had not yet picked up the parts. We argued the claim was not compensable because he had not picked up the part and he failed to eliminate idiopathic causes. The hearing officer agreed and disallowed the claim. A janitor at a refinery bent down to pick up styrofoam cups from underneath some chairs when he felt pain in his back. He was diagnosed with a lumbar sprain. The hearing officer allowed the claim. Now for this one, the employee had a history of back problems, but his new complaints were on the opposite side from his pre-existing condition.
In addition, he had a metal rod in his femur from a prior injury that caused him to bend in an unusual way, making him more prone to sustaining an injury from bending.
And this one in particular, I think, does not make any sense because having a metal rod in your femur seems to me to be a pre-existing condition, idiopathic, so I would think that that would be what elevated his risk and not something incident to his employment, but the claim was allowed. What about injuries when the employee stands up from a bended or kneeling position? An employee at an auto supply store was kneeling down to inspect a customer's tail light. When he stood up, he felt pain in his lower back and upper hip. His injury was compensable. The court noted that the injury occurred on company premises and while he was performing a normal job activity that benefited the company. And he also had no pre-existing or idiopathic condition that would have caused the injury. We handled a claim involving an electrician who was kneeling while working on a starter motor. As he began to stand up, he put the majority of his weight on his left leg and felt a pop and burning sensation in his left knee. He was diagnosed with a meniscus tear. Now, this claim was compensable. We argued that him standing up did not arise out of his employment, that it was idiopathic. But the hearing officer disagreed and allowed the claim, finding that the employee's work activities, going from squatting to standing, put him at a greater risk than the general public for developing a tear. And then in another claim that we handled, an employee was stacking packages. He bent down to push in a cardboard tab on a pallet and felt back pain when he stood up. He was diagnosed with a lumbar strain. This was compensable. So we argued this was idiopathic because there was no real mechanism of injury. He was just bending down. However, the hearing officer noted that his job task in particular required him to stand up from an unusual and awkward bended position, and therefore the injury was related to his work. Ordinary movements such as reaching. We handled a claim where a millwright quickly reached out to stop a piece of equipment from moving so it would not damage other pieces of equipment. He ruptured his biceps tendon. This claim was compensable. So we argued his injury was idiopathic because he was simply reaching, which is kind of a weak argument. The hearing officer noted rapidly reaching out to prevent equipment damage is not an everyday event. The hearing officer also found the employee worked in a cramped space with a rotating piece of heavy equipment, and that put him at a greater risk of a ruptured tendon from sudden movement. All right, so one more ordinary movement. Some people injure themselves just by walking, and we have had a few walking claims. A mechanic was walking into the plant when his knee popped and gave way. He was diagnosed with a knee sprain and a meniscus tear. We presented a report from a doctor who opined that the injury was caused by the natural deterioration of tissues. This claim was disallowed. The hearing officer found that the injury was idiopathic and that there was no danger associated with work that caused the injury. Next one. A factory worker was returning to his workstation after a break. He placed his left foot upon a ramp and was preparing to push off with his right leg when he felt a tear in his right calf. His claim was not compensable. The hearing officer disallowed the claim as idiopathic, noting that the employee was injured when simply performing the act of walking. And then the last walking claim, an employee stepped wrong while walking and her knee popped. And for this claim, we actually had emergency room records where she had presented 5 days prior to this injury after twisting her knee playing on a trampoline at Sky Zone. So as you can probably guess, claim was disallowed as idiopathic with no relationship to her employee. Now I have two more mechanisms of injury, and the first up, as you see, and maybe the first for you, is injury by sneezing. And I'd like to see what you think about these. So an employee's hands were raised to shoulder height while operating a press. He sneezed and dislocated his shoulder. Do you think that that claim was compensable or not compensable? Anybody else want to guess? Yep, 3 compensables. You're right, it was compensable. And that's because even though you would think sneezing, idiopathic, but the employee sneezing combined with the fact that his hands were raised to do his job, that made the claim compensable and connected to his employment. And then the next sneezing injury, we handled this one. Similar outcome, a factory worker was pulling a skid weighing over 300 pounds with his arm stretched out when he sneezed and felt back pain. Compensable. He did have a prior back injury, and we had a report from a doctor who opined that the sneeze alone causes the injury. Regardless, the hearing officer allowed the claim for a lumbar sprain, finding that the employee's job task of pulling a heavy skid in coordination with his sneeze caused the injury. Our last idiopathic injury. So injuries from motor vehicle accidents can be idiopathic. We have a case where a home health care nurse became unconscious on the way to a patient's home. She crashed her vehicle into a light pole and sustained fractures. She had a history of diabetes, passing out, and blood pressure problems for which she had not been taking her prescribed medication. Her claim was not compensable. The court noted that she had to prove her injury was not idiopathic, or She had to prove that there was a risk of her employment that made her injuries worse. She argued that the light pole and the roadway were risks incident to her employment because she was a driving employee. And this made her idiopathic injury compensable. The court disagreed, finding that the light pole was unrelated to her employment, and there was no evidence the roadway was unsafe. The court noted this injury and accident could have occurred anywhere else when she was off the clock, not working. So the takeaway is that when you are presented with an injury with no apparent cause, you should take the time to fully investigate. You should view any video footage that exists, because that's going to be important in the hearing room. Go out to the site where the incident happened to look for hazards. Interview any witnesses. And if after you've done your due diligence, you're still scratching your head and wondering how in the heck this happened, how did this happen, you might have an idiopathic injury on your hands. Any questions? So the question is, does the coming and going rule interact with this? And it can, and I think that was referring probably to the motor vehicle accident. In that particular case, because she was a driving employee, it's likely that, she was still on the clock during the time, and so if that had not been an idiopathic injury, it would have probably been compensable, the accident. All right, well, thank you for your attention, and I hope you enjoy the rest of the afternoon.